This lesson covers title assurances, title opinions. So I'm not going to discuss the section in detail on the recording system. We'll just generally say that title opinions are based on searches of public records. I think the book was pretty self-explanatory, and I talked at length with Barbara Stewart about how she searches or how she gives her title opinion. So you can reference those two sources. But I would like to briefly go over the Luthi v. Evans case. So this case offers some insight on when recording of a title does not provide constructive notice. So generally, if a title is recorded, then future parties are found to be on notice of that owner's claim to the land. But there are some exceptions to that rule, and Luthi v. Evans brings those out. So this case briefly has to do with a Mother Hubbard instrument. And what that is it's a conveyance in real estate where the property is not described using a specific property description. There is a general language in the conveyance, so it'll say something like all the grantor's property in a certain county. And the court in this case holds that Mother Hubbard instruments are valid as long as they're executed and delivered. Right, we meet all those elements. It'll be a valid conveyance. But because Mother Hubbard conveyances don't have a specific description of the property, even if they're recorded, they do not constitute constructive notice to any subsequent purchaser of the owner's interest. So the court on page 604 says that to impart constructive notice to a subsequent purchaser or mortgagee, the recorded instrument needs to have described the land that's conveyed with sufficient specificity that the land could be identified. And so from this case, we can draw that recorded documents that do not have a specific property description that allows for um, future purchasers to be able to identify the property are not going to be found to give that future purchaser constructive notice. Now, what's interesting is the court does state that even if a deed is that if a deed is specific and it's incorrectly indexed, so by the indexing clerk, that's still enough to provide constructive notice. But in the case where the property description is not specific enough, that is not sufficient to provide constructive notice. Why is there that difference? Well, essentially the recording party has done everything that's within their power to comply with their requirements. They have recorded, they have a specific description. They can't control the government official that is responsible for indexing the property. All right, let's move on to recording acts. Every state starts with a first in time rule. And a first in time rule generally says that whoever's property interest is created first prevails. All right, so the first property interest is going to be the one that prevails. But almost every state also has a bona fide purchase doctrine. This bona fide purchaser doctrine supersedes the first in time rule if it's applicable. A bona fide purchaser is a party that comes along and in good faith purchases property that they believe has good title. To qualify as a bona fide purchaser, the subsequent purchaser must not have actual notice or constructive notice. We'll discuss what those two concepts are a little bit later. For now, we're going to discuss for bona fide purchaser doctrines, states have there are different categories, there are different ways they could define who qualifies as a bona fide purchaser. And states typically come out on this issue three different ways. The first is we have race states. The second, we have notice states. And then we have race notice states. And you might remember from my conversation with Barbara Stewart that North Carolina is a race state. So you have some context now for what we were talking about. So the race state says the purchaser who records first has priority. Doesn't matter when the interest was created. What matters is when the document was recorded. Okay, when the deed was recorded. So again, North Carolina is a race state. The second type of recording acts are notice recording acts. These acts say that the bona fide purchaser has priority. The bona fide purchaser has priority. So when a purchaser takes without notice, their interest prevails over uh, prior interests. So here, the purchaser doesn't have to record to get the interest, as long as they were a subsequent purchaser and they paid a value that was a fair value, they prevail as long as they didn't have notice of the prior interest. They're still motivated to record, though, because if they don't, another subsequent bona fide purchaser could have superior title. The third jurisdiction is a race notice jurisdiction. These kind of combine the race and the notice jurisdiction theories, and they protect subsequent purchasers for value who take both without notice and records first. Okay, so they're without notice and records first. So this is a subsequent bona fide purchaser, which means they don't without notice, who also records first. Next case in the book is Messersmith v. Smith, and it is in a race notice jurisdiction. So remember, under the statute, in order for a subsequent purchaser to be protected, they need to be a bona fide purchaser, meaning they have no notice, and they also needed to have record their title. The question in this case centers around what happens when one of the recorded deeds was not acknowledged. Acknowledged means that it was signed before a notary who can attest to the identity of the grantor. Whenever you get a case or a fact pattern that's as complex as this, it is always good practice to draw out or write out the chain of title. So we're going to do that here. So first, Caroline Messersmith conveys to her nephew, Frank Messersmith, her interest in the property that they own as co-tenants. Now, you can use whatever notation works for you. I personally like to number the transactions so I remember which order they went in. After Caroline Messersmith conveyed her interest to her nephew, she then executed a lease to Herbert Smith. I've gone ahead and written in the interest that's conveyed as well, so we can keep track of it. So we have a lease that's executed, but in order to execute a lease, you have to have some title in the property, and Caroline already conveyed all of her interest. Okay, so after she executed the lease, she then entered into a third transaction where she conveyed an undivided 1/2 interest in the mineral rights to Smith. Okay. But there was a typo in that deed. So she again conveyed her 1/2 interest. But this deed here was not acknowledged. It also helps if you have multiple colored pens when you do these. Okay, so Smith records then, Smith first conveys his 1/2 interest in the mineral rights to Seal. All right, so here we have the fifth conveyance, right? The interest rights go to Seal. Then Smith records the lease, right? Smith records the lease. After Smith records the lease, he goes and records the corrected deed. So that's this deed here. And that's step 7. So step 7, Smith records the mineral rights. Then Seal records his deed. I like to use red for recording because you can't miss it. And finally, Fred then records the deed. So we have step 9, right? Frederick records the deed. Okay, that's a bit of a messy pattern, right? So Frederick sued to quiet title. All right, let's go through and figure out who owns what. All right, so this second conveyance here was invalid. Why? Because Caroline can't convey property or an interest in land she does not have. She has no interest in the land after this conveyance. But this conveyance here was not recorded. So then the question you have to ask is, can Smith argue that he was a bona fide purchaser? Well, at this point, Smith he only has a lease. So what about this interest? Could he claim to be a bona fide purchaser here? Well, the issue is, sure, he meets a few of the elements, right? He paid value. He was not on notice because he didn't actually know and didn't have constructive notice um, because Frederick had not recorded the deed, right? So he meets these two elements. But the court is hesitant, or the issue the court is faced with is that the deed was not properly acknowledged. The deed was not properly acknowledged. He also met one additional element I forgot to mention, which was that he recorded before. So this is erase and notice state, right? So he still would also have to, he would also have to record. And here we see that he recorded step number 7, and that was before Frederick recorded. So he meets all of those elements. However, there was a defect with the recording. Because this deed was not acknowledged, then it can't be deemed to be recorded. So unacknowledged deeds are not recorded. So that means that this recording was invalid, and so Frederick was able to quiet title. All right, we're going to do some recording problems, but right just before we do, I just want to go over the rules one more time so you have them fresh in your mind. Here are the various rules. You can have a race jurisdiction or a race statute in which the purchaser who records first has priority. You can be in a notice jurisdiction where the subsequent bona fide purchaser has priority because as long as he has no actual or constructive notice. Or you can be in a race and notice jurisdiction where the subsequent bona fide purchaser who does not have actual or constructive notice and also records first is the one who prevails. Okay, so let's apply these rules to the following problems. S conveys to B who does not record. Then S conveys to C records, and B records. Now this is just a personal preference, so if this works for you, go on ahead and use this technique as well. To me, this way of writing out the conveyances is helpful in that it helps me put things in order, but I don't see the connections. And so what I like to do is to actually draw out the connections, and I'll demonstrate how. So first, S conveys to B. There's no recording here. Then S conveys to C. And there's a recording here, so I just put an R. Then, oops, come on, pen. Then B records. Whose interest prevails? Well, that's going to depend. We're going to have different answers based on if we're in a race jurisdiction, a notice jurisdiction, or a race notice jurisdiction. Sorry, y'all. Teddy is playing with his toy in the background, so that's the squeaky noise. All right, so if we are in a race jurisdiction, and it's a pure race jurisdiction like North Carolina, then it is the party that records first. So the answer would be C. In a notice jurisdiction, it would still be C. Why? Well, because C was the subsequent purchaser of value who took without notice of the prior conveyance, and B did not record. So if we have a race notice jurisdiction, what's the answer? Still C. Why? Because C was the bona fide purchaser. They took without notice, and they recorded first, right? Let's go on to the next problem. C conveys to B, who does not record. All right, so here we have S conveys to B does not record. S conveys to C as a gift. C records, and then B records. All right, so let's say we are in a race jurisdiction, notice jurisdiction, race notice jurisdiction. So in a race jurisdiction, the first purchaser who takes for valuable consideration and to record the conveyance wins. So here, because it's a gift, it is not going to be considered for valuable consideration. And so in a race jurisdiction, B would own Green Acre, not C. In a notice jurisdiction, B would also own Green Acre because, again, you need to qualify as a bona fide purchaser, you need to have purchased the property for value, which C did not. C received it as a gift. And again, for race notice jurisdiction, B would prevail for those same reasons. All right, so next problem, problem 3. S conveys to B, who does not record. C conveys to C, who does not record. C conveys to D, who does not record. Then C records. All right, I drew out a little diagram here with the first steps. So if we were in a race jurisdiction, it would be the first person to record. And so C's title would prevail. If we are in a notice jurisdiction, then the last bona fide purchaser is going to be the one that takes. So it doesn't matter who records, it's the last bona fide purchaser. So we got 1, 2, 3, D was the last to purchase, D takes. In a race and notice jurisdiction, it is the last bona fide purchaser that also records. So in that case, the only bona fide purchaser that recorded was C. So C would get the property. I want to introduce one more recording rule to you, and that is the shelter rule. And it says that a bona fide purchaser is allowed to transfer their protection to a later grantee. Okay, so as long as one bona fide purchaser qualifies for that protection, then if they transfer the land, then the grantee can also qualify. They can transfer that protection. Okay, let's take a look at the next problem. We'll apply that rule. All right, so here's the diagram I drew. Let's say we're in a race jurisdiction. Who takes? If we're in a race jurisdiction, D actually is going to be the one who takes. Let me explain why. C recorded before B did, right? So they were the first to record. They would have been the ones who who had superior title. Now the shelter rule allows C to pass that priority to D. So in this case, D was technically the first to record, vis-a-vis C. In a notice jurisdiction, who would take? Well, D would still take because D was able to take C's bona fide status because of the shelter rule, right? So D on his own did not qualify as a bona fide purchaser because B had notice of S's transfer to B, right? But they can take advantage of C's bona fide purchaser protections. So D would still take. All right, what about erase and notice jurisdiction? Well, here again, D owns Green Acre because of the shelter rule. All right, that's going to end this video. And coming up next, We're going to have Board of Education of Minneapolis v. Hughes.